Welcome to Latte with a Lawyer, a podcast dedicated to bringing you the stories of some of America's most successful lawyers, figuring out what makes them tick, how they creatively solve problems, and how others aspiring to be them can follow in their footsteps.
Okay, good morning, everybody, and welcome to another episode of Latte with a Lawyer. I'm your host, Jonathan Brickman, and this morning we have Jim Heinen, and he's with the law firm Armstrong Teasdale. Welcome to the show.
Good morning. Thank you for having me.
Excellent. Good. It looks like you're still drinking coffee.
Yeah, well, I figured if I was going to be on a podcast called Latte with a Lawyer, I needed to have something to drink. Yes.
All right, good. So what's your morning jet fuel?
It is coffee black. It's funny. I never drank coffee until I was in law school, and I did it out of a necessity to stay awake in class. Obviously, some very long nights and some very long classes. But I started drinking coffee and just black. I was concerned that if I started putting sugar and cream in there, I would really like that, and then it would become more of like dessert. And so I've remained with just black coffee throughout my life. Now I will have an occasional latte. My wife is a big latte drinker, and I'll do that from time to time as well. But generally, it's just black coffee. I'm a Tim Hortons guy. I like Dunkin' Donuts coffee. Their hazelnuts very good. So just black coffee. Go.
That's hilarious. Wait, so Tim Hortons? No kidding. That's Canadian franchise. So
I know. Yeah, they my son plays hockey. I'm a big hockey fan, and I don't know if that's why I like the coffee or not. But they had a couple of Tim Hortons in St. Louis for a while, and then they went away. But I kind of got hooked on Tim Hortons coffee in there. So I still buy you can see the Keurig. Well, people on the podcast can't see it, but I have a Keurig over my right shoulder, and I have the Tim Hortons Keurig pods that I drink pretty often.
Oh, that's hilarious. How your son's a hockey player? What level is he?
He's a squirt. So he was a first year 10U last year. He'll be second year 10U coming up this fall.
Oh, good. Were you a hockey player yourself?
No, I was soccer and baseball, and I grew up just across the river from St. Louis in a town called Belleville, Illinois. When I grew up, there were only one rink maybe on the east side of the river there, and it was like 30 minutes away. Now where we live in St. Louis, there are, I want to say, maybe 6 rinks within 20 minutes of where we live. It's insane. The hockey has blown up here, youth hockey, over the past 25 years, and there's rinks everywhere now, and everybody plays, so it's great. But I've always been a diehard Blues fan and always loved watching it, so it's a fun sport to watch.
Oh, that's hilarious. Now, my son played hockey growing up, and I told him when we moved to South Florida, I thought he'd be the best kid on the ice, and he wasn't. The kids who play hockey here are really good. And,
we played in a tournament in Tampa in January down there, and had some really good competition. It was fun.
Yeah, good stuff. Well, let's talk about your law practice. Tell us what you do. What's your business?
Sure. So I'm a patent attorney. I am a patent prosecutor. I don't know if you know the difference between prosecutors and litigators. A prosecutor, which is what I do, works with inventors and corporations, universities, to take a patent invention, file a patent application on it, and try and procure a patent. And there's a myriad of other things that we do as well, but we don't go to court ever. Well, I shouldn't say ever, but we don't go to court very often at all. But we're generally working with inventors in the patent office. Patent litigator, on the other hand, that is someone where if you have a patent and someone you believe is infringing your patent, then they will litigate the matter. They will go to court every now and then. But no, I'm a patent prosecutor. I have a chemistry background behind me there from Miami University in Oxford, Ohio, and which kind of leads to, I guess, a question you had of why did I become a lawyer? So as a chem major at Miami, I didn't really know what I wanted to do with my career, and I've seen this is kind of a similar path to other patent attorneys now that I've been in this business for a while. I went and I worked at the Sherwin-Williams company at their headquarters in Cleveland, downtown Cleveland, right on the Cuyahoga River there, and was in a lab and overlooked the river, and it was a great summer job. I made paint and deck stains from scratch. But I kind of looked around and saw some people who'd been doing it for 15, 20 years. And I was like, it's not what I want. It's just not for me. They loved it, but it just wasn't for me. And so then I started looking at alternative paths I could take with the science background that wouldn't be going to grad school or doing research or being in a lab. Someone from Procter Gamble came and spoke to the chemistry juniors, the majors when I was there, and mentioned patent law. And I thought, oh, that sounds kind of interesting. And so then my senior year, I took as many law classes as I could and really enjoyed it. And so then I went to law school. I went to law school with the idea that I was going to become a patent attorney. At the time when I was doing that, most people who were patent attorneys had gone and worked in the industry for a couple of years first, or they went and they got their PhD or their master's degree, and then decided they wanted to go back to law school. But I went straight from undergrad to law school. And then I started off my career as an employment attorney, believe it or not, in Washington, D.C., primarily because if in one of the pieces of advice I have for people later on is I didn't take the patent bar when I was in law school, and I wish I had.
Yeah.
It's a huge advantage to have when you graduate to try and find a patent attorney career. Sometimes people will they'll hire you and then they'll help you take it your first or second year that you're working with them. But in any event, I worked as an employment attorney for a little over a year and a half in Washington, D.C., took the patent bar, fortunately passed it, and then started with Armstrong Teasdale in 2008. It'll be 15 years this summer, and I've been doing patent law ever since. So it's a long-winded way of how I became a lawyer.
Interesting. So any of the lawyers in your family? Well, you got a bunch of scientists. That's why you.
No. My mother worked in the education industry for a long time. My dad was a stockbroker. So there were no attorneys in my family. And quite frankly, it's funny because I don't really think of myself as a lawyer because you think of lawyers, you look at the movies and they're going to trial and they're arguing with the judge and yes, I'm an attorney, but I don't do any of that. I'm still doing a lot of science. So it's fun.
Oh, interesting. Yeah, why the interesting chemistry? It's funny. I remember when I was a high school student, I had to take this AP chemistry class. And I don't know why I did. I didn't like it, but the guy next to me was really into chemistry, and he helped me get through it. And it's funny, he ended up getting his PhD in chemistry and worked for like Dow Chemical. It was really his calling. For me, it was just like, to take the class and like boost my GPA, but I was never really interested in chemistry.
Yeah, it's a two-part answer to that. One is I enjoyed the combination of the science and math.
Yeah.
I was enjoyed math. So I like that aspect of it. And then it was my sophomore year in high school, just a great chemistry teacher, and turned me on to it. And it seemed like it was, like I said, a good combination of things that I enjoyed doing. My dad also convinced me to major in chemistry because it would be, in his opinion, easier to switch from chemistry to something else as opposed to vice versa. And with a chemistry background or any technical background, it might open some doors that other majors may not, which it did for me because I ended up being an attorney with a chemistry background.
Sure.
So it all worked out. But yeah, that's how I got into.
Oh, interesting. So let's talk about more about prosecuting patents. So tell us exactly what that means. So you said university, so you work in the tech transfer office?
Yeah, that's right.
Okay.
Yeah, so tech transfer offices. So the prosecution of a patent, it starts, well, the patent application process starts really from the conception of an invention. So if you came up with the invention or an idea to create a coffee mug, maybe it's a coffee mug that is black, but then when you heat it up, it changes color. So when you put coffee in it, it changes color. I have one of those, actually.
You have one of those.
I had got that from Sedona, Arizona recently. It's pretty cool.
Nice.
But if you came up with that invention and you wanted to start selling that invention, the first thing you should think about is, okay, how do I protect my idea so that someone doesn't rip off your idea and starts doing it themselves. So you would come up with what we refer to in the industry as an invention disclosure form, where you write down what is your invention, What's the title of your invention? Why is it new? Why is it not obvious based upon something that's already been done? Is there some long felt but unresolved need to have a coffee cup that changes color? So you dump all of that information into this invention disclosure form, reach out to an attorney like myself, and then generally what we will do is we'll do a patentability search where we'll go and we'll look and we'll scour different databases to see if there are any patents that are out there, applications, or any publications where someone has done this before. And if they have, then we'll come back and say, well, you probably, it's not worth your money to file a patent application. It doesn't mean you can't, create this and still make a lot of money on it, but you probably can't protect it for yourself. But if everything comes back clear, then we will work with you and we'll draft the patent application. And we will file the patent application with the USPTO, United States Patent and Trademark Office, and that's when the quote-unquote prosecution begins. So the patent office will review the application. They will determine whether or not you should be receiving a patent or not. Generally, it will come back with a rejection right off the bat, which is fine. The approach you generally want to take is you want to try and claim things as broadly as you can and make the patent office narrow your invention, because what you don't want to have is a patent that is so limiting that anyone can dance around it and make the same mug that you have without infringing your patent. Then all you have is an expensive piece of paper. So you want to avoid that. But the patent office then will either reject or allow the application. If they reject it, then it's our job as attorneys to work with you as the inventor to prepare a response and file that response with, maybe we think the patent office is incorrect. Maybe we make an amendment to our application, to our claims, to try and evolve or to navigate around the prior art that's out there until eventually, hopefully, we get a patent that is allowed for you. And so that's the prosecution process.
Okay. And in the event that, so the patent is accepted, someone is patented, and then there's an infringement, you have another team that would litigate?
Yeah, yes, correct. And we'll work closely with them. Oftentimes our litigation team will have a prosecutor or two working on a case. It depends on two things. One, how technologically savvy are the litigators? And we have some people that have passed the patent bar and are great and they don't really need any help. And two, how specific is the technology? If you're getting into really deep software and electrical patents, then it's helpful to have someone with that specific background to help you convey the meaning of the claims and the actual invention. Same thing goes if it's a really deep pharmaceutical application. You want someone who has a PhD and understands that stuff very, very well to help you with it. So we work together pretty closely.
Okay. Do you focus on any type of industry?
Oh, no, not one in particular. So at our firm, we have a very deep bench. Right now, we currently have around 70 intellectual property attorneys. Of those, we have 8 trademark attorneys. We have around 17 IP litigators, and the rest are patent prosecutors. That patent prosecution group is broken down into 3 subgroups. It's a chem bio subgroup, which I'm in. There's a mechanical subgroup, and there's an electrical engineering / software / computer science subgroup. So if someone has a technology that can be patented, we can help them with it. So we don't focus on any one thing in particular.
Oh, I can see, but you're in the chemistry group.
But I'm in the chemistry, yeah. So I'll very few electrical or software based applications will I touch because I just don't understand it, and the clients don't want someone who doesn't understand it working on it. But the chemistry stuff and the biochemistry stuff I can work with, and then also if it's a hybrid mechanical, or I can do some mechanical work as well. A lot of people have with their backgrounds can do the hybrid within those 3 subgroups that I mentioned. But if it gets very specific, then you have someone with a background who can handle that. And we staff everything accordingly that way, and the clients are aware, and it all works out well.
Okay. And do most of your people have terminal degrees, or doesn't matter?
It doesn't. Well, it does and it doesn't. How's that for an answer? It's like a law school answer. It depends. You don't have to have a PhD or a master's degree to be a good patent attorney. Does it help? It can. Sometimes PhDs are not the best patent attorneys because they're still too entwined with the educational. They want to read everything in depth. They want to really get into the weeds of something, and they have a tough time separating their educational experience with what it means to be a good, efficient attorney. Those things don't always jive. Sometimes, however, having that background is fantastic for knowing the invention very well, knowing the prior art that's cited against it very well, and being able to differentiate and point out why they're different, why we should be getting an application. So does it help? It can, yes. It's not necessary. If you can find someone with a complete package who has the PhD, who's a very efficient, fantastic attorney, those are great to have. And so it can help, yes, absolutely.
Yeah, that's interesting. It's the same in business too, right? Like how much time should you spend on the product versus being a salesperson, right? They're really separate things, right? I mean, because you can support with experts, right? If you don't have this deep knowledge about the subject, right?
Correct. Yes, yes, yes.
Yeah, interesting. So what do you think the traits are then that make someone successful in what you're doing?
So good question. As a patent attorney, the traits, in my opinion, that make someone successful are: do you put forth a quality work product? Number one. Number two, do you do it in a timely manner? And then number three, are you efficient? A lot of the work that we handle can be done on a fixed fee basis. And so you're given a budget, and that's the budget within which you need to work.
Yeah.
So you need to be able to meet a deadline. You need to be able to have the quality work product that the client is going to like, and you need to be able to do it within the budget. At any given time, it's relatively easy to do two of those three. It's very difficult to do all three of those at once sometimes. And so that's a battle that pretty much every patent attorney deals with throughout the course of their career, because oftentimes as you grow as an attorney, your billable rate increases. Sometimes the fixed fees don't always increase with those. And so you have less time than what you used to do it. Now, the more you understand a technology and the more you work with the client, you should be becoming more efficient, and you shouldn't need to take as much time to work on it. So those are traits that I think make a successful patent attorney. Discipline, being able to communicate. Those are also two things. There are internal deadlines and there are real deadlines, right? But you shouldn't differentiate between those as an attorney. If a partner asks you to get something done by a certain date, even if the due date for PTO isn't for a month later, meet that deadline. Treat the partner like you would a client. And if you do that and you keep the partner happy who's giving you work, they're going to give you more work, just like you would do that with a client. So make sure you meet your deadlines and make sure you communicate. That's one of the biggest things that people struggle with, especially when they're younger attorneys, is they want to please everybody and they don't want to say no, and they'll take on a massive amount of work, but then they can't get to all of it, and they're afraid to tell someone that, and then the deadline comes and they've got to go talk to the partner, hey, I wasn't able to get to this, and things don't go well. No, you need to know when that situation is going to arise and communicate early and often. And sometimes that's when someone comes to bring you work and you say, look, I can do this, but I can't get to it till this date. Are you okay with that? And they may hem and haw a bit and say, okay, that's fine. But at least they know, and they know up front, and you're not dropping a bomb on them right at the last second that you didn't get to something. So communication is critical, especially in this day and age where we now have over 17 offices worldwide. Yes, we can Zoom, we can jabber, we can talk on the phone. You need to make sure you talk to people, because we have attorneys working across all of our offices. I'm in St. Louis, but I work with people in Boston, in New York, in Denver, in London. And so you have to communicate, and you need to make sure you do that well.
Excellent. It sounds like a job description for anyone listening.
Yeah. And I'll throw one more in there as well, is you need to have, at least to be a successful patent prosecutor, you need to have a certain amount of mental agility. And by that, I mean, in any given week, I'll work on 6 or 7 different inventions, 6 or 7 different clients. And when I come into the office each day, oftentimes I'll have laid out, okay, here are the 2 or 3 things I'm going to work on. I get to my desk, I open my emails. Nope, here's 2 or 3 fires I need to put out. And so you need to be able to quickly transition from what you thought you were going to do that day to what you need to do that day, and then still get the other things done. But that comes with practice, and that comes with experience. But it's a very rapid and quick evolving practice, at least from the prosecution standpoint. But I like that aspect of it, because it keeps it quick. and it keeps everything fresh, and you're constantly seeing the cutting edge of technology. As a litigator, you're going to be maybe working on a patent litigation case for a year or more, and it's the same case over and over. As a prosecutor, you're seeing a much quicker turnaround on projects and new things coming through. So mental agility and be able to handle a variety of topics on any given day is important.
Good stuff. I like that. So what kind of technology do you use to make yourself more efficient, the firm uses?
Well, right now I have 3 monitors spread out, so that helps.
Me too. I got 3.
Yeah, so that's one. That was before the pandemic. I just had one, right? And so now, what kind of technology do I use? The 3 monitors helps. I have my email up on one. I have on the other one my spreadsheet where I keep track of my time on a daily basis, and then on the one I'll have a project that I'm working on. So I'm constantly working on 2 or 3 things, or I have windows open where I can bounce from one to the other. So that's helpful. We use Jabber, Cisco Jabber, which is like I always refer to it as AOL Instant Messenger. You probably remember that. I don't know.
Yeah.
It was popular when I was in college, and nobody uses it anymore.
No.
But where you can message someone within Armstrong Teasdale, no matter where they're located. You can send them a quick
That's
note.
funny. I didn't realize. I mean, most people use Slack these days, so I'm sure it's like similar.
Yeah, so it is, and it's just shooting them a quick. It's like texting them with the keyboard,
Sure.
right? So if I'm on a call, or if someone, I have 5 messages right now on Jabber, and so if something urgent's coming up, I can quickly respond to it. So we use that, which is helpful. Obviously, we have laptops that we can take, which is the blessing that occurs. The laptops and the VPN with our phones, we can do work anywhere we go, which means that you can be contacted and you can do work anywhere you go. So sometimes that's the expectation. Other technologies we use, we have an internal financial tracking system we use where you can look at fees collected and fees billed from certain matters for certain clients. Are they behind on payments, or is there work that needs to be billed that hasn't been billed yet? I use that every day. I look at that every day, and most attorneys do as well. We're getting very close to updating some of our internal software on how to assign projects and being able to track who we could really use that, and where I can quickly look at an associate in the group and see what 7 projects are they working on, and hopefully what's the progress on each one of them. Are they almost done? So then I can verify whether that person is overloaded or they have some capacity. So when I'm looking to distribute work, I then know who I can go to. So that's something we haven't finished yet, but we're getting close to that.
Cool. Okay. Excellent. Good stuff. And your litigators, I mean, do they ever go to, I'm curious, do they go to trial? Do they try cases?
Yes, we just had a big one last October down in Texas, and they lived down there for 6 weeks. And so then we had one that was supposed to go to trial for 2 weeks in Wilmington this week, but it settled on Friday. So just like any other litigator, sometimes the cases go to trial, sometimes they don't.
Excellent. Good stuff. Good stuff. Well, listen, just to round off here, final thoughts you want to leave with the audience about your firm and the best way to connect.
Yeah, so with our firm, we're a general practice firm. We can handle pretty much any type of law. We do a great job as a firm collaborating across our practice groups. So if there's a client that we service with employment and labor needs, very often we're going to be doing their IP work as well. And so we have a very deep bench for IP, as I kind of talked about earlier and illustrated. So any sort of IP technology that anyone wants patented, we can help with. We can litigate any matter, like we also for trademarks as well. We have a growing practice there, and so any IP needs you need, we're a great firm for that. Like I mentioned, we have close to, I think maybe over 70 IP attorneys now, which has grown considerably over the past 10 to 15 years. IP is a huge driver of our firm's revenue and our firm's growth, and we'll continue to do so. So if any IP needs you have, we're happy to do it. Like I mentioned, we're located all throughout the globe, all throughout the country, and we continue to grow. We just opened our Chicago office this month. And so we're everywhere. We can get to everywhere we need to get to within the country and help people out. So what was the second part of your question? Sorry,
Oh, just best way to connect if they want to.
Best way to connect is always email is great. I don't know if you have my email address, but you can go to our website and you can look at our industries and our practice areas if you're looking for a type of law that you need someone to help you with.
Good deal. Excellent. Well, listen, good. It's been interesting learning about patent prosecution.
That's right. Yeah. Is your son still playing hockey?
He gave it up. Yeah.
Okay.
Much to my chagrin, he gave up the hockey. Now he's a college student now, so he's practicing his academic stuff.
Excellent. Good.
He gave up hockey. Anyway, I was a basketball player growing up, so I was not that. Although I have to tell you, watching him play hockey, I love watching hockey. It's a great sport.
It's a lot of fun. Yeah. Brickman, not the best last name to have for a basketball player, though, right?
It's really not. You don't be shooting bricks. For sure.
Yeah.
So, I don't know if you're watching the playoffs, but there've been some pretty exciting playoff games. Miami Heat the other night came back with quite a comeback and win. And last night I watched my Boston Celtics lose, like literally at the last second.
Oh no, I'm following the hockey playoffs. I don't follow the NBA that closely. The hockey ones are good. Are you a Bruins fan? Because the Bruins are looking strong this year.
Yeah, they are.
Yeah. Now the Celtics, their best player is from St. Louis, and he's a big icon around here.
Oh yeah. I mean, I'm not much of a sports fan anymore these days. Yeah. But let me just finish this off here. But just for the audience, I just want to let everyone know Jim Heinen, again, not to be confused with Heineken. You might like Heinen. Right. From Armstrong Teasdale. And this is sponsored by EmotionTrac, which is a legal tech platform. We help litigators prepare for mediation trials with our insights and survey platform. But listen, thank you, Jim. It was really a pleasure.
Yeah, thank you very much. I appreciate you letting me meet with you.
Oh, you bet.